Case number 19-105661NH, Alexandria Marie Scott versus Sure Hospital and Dr. Jason Terrence Wells. Appearing on behalf of the plaintiff is attorney Bart O'Neill. Leon Walsh appears on behalf of the plaintiff. On behalf of the defendants in this case, attorney Jonathan C. Martin. Mr. Martin, you may proceed.
Thank you, Your Honor. Your Honor, we have three motions in limine that are scheduled for hearing today. If it's okay with the court, I would like to proceed first with the motion in limine regarding the plaintiff's unsupported liability theories.
You may proceed.
And does the court want me to argue all three of them and then hear from the plaintiffs, or take them one at a time?
Let's take them one at a time.
Okay, thank you, Your Honor. Your Honor, this case arises out of a surgery to remove the plaintiff's gallbladder that took place on June 8th of 2017. The complaint was filed on December 6th of 2019, and there was extensive discovery done that included the deposition of plaintiff's only expert, Dr. Francis Leigh. After that deposition, we filed a motion asking the court to dismiss the case, or in the alternative to hold a Daubert evidentiary hearing to determine whether or not the opinions offered by Dr. Leigh were reliable. And the court did order a Daubert hearing. The court heard extensive testimony, not only from Dr. Leigh, but two of the defense witnesses as well. The court then determined that the opinions of Dr. Leigh were not sufficiently reliable to be heard by the jury and dismiss the case. The plaintiff appealed, and the Court of Appeals issued an opinion in March of this year in which they affirmed the trial court on 4 of the 5 issues, but did reverse as to 1 issue. So the purpose of this motion is to asking the court to enter an order limiting plaintiff's theories that they mention in argument or that they elicit from their only expert, Dr. Leigh, to the one theory that the Court of Appeals said was sufficiently reliable to be heard by the jury. And that theory is that a claim that it was negligent for the operating surgeon in this case not to switch from a laparoscopic procedure to an open procedure. And we're simply asking the court to enter an order prohibiting plaintiff from making arguments or eliciting testimony or introducing any evidence that goes beyond that theory of liability. Now, I know in response, plaintiff says, well, there is a court rule that allows the court under certain circumstances to amend the pleadings to conform to the evidence. I think it's important to read that court rule pretty closely, though, because that court rule, 2.118C, has 2 components. It says, number 1, when issues not raised by the pleadings are tried by the express or implied consent of the parties, they are to be treated as if they had been raised by the pleadings. But we're not giving any express consent to try any issues other than the one that the Court of Appeals has indicated is to be heard by the jury. And then the second part of that, 2.118C2, is if evidence is objected to at trial on the ground that it is not within issues raised by the pleadings, amendment to conform to that proof shall not be allowed unless the party seeking to amend satisfies the court that the amendment and the admission of the evidence would not prejudice the objecting party in maintaining his or her action or defense on the merits. So we've been through extensive discovery. We've been through an extensive evidentiary hearing. We've had the trial court's ruling. We've had the Court of Appeals ruling. And it's clear that the only issue in this case is the theory that there was a negligent failure to convert from a laparoscopic procedure to an open procedure. So we're simply asking the court to enter an order limiting plaintiffs to that theory.
Thank you. Mr. Walsh, your response, sir?
Yes, Judge. While we do agree that there is, only the issue of failing to convert from the laparoscopic procedure to an open procedure, we just think it would be premature to issue a blanket ruling precluding any amendments should that issue arise during the trial. So that's our position, and I'll leave it at that, Your Honor.
All right. Any other comment?
No, Your Honor.
All right. Well, what is in play is 2.118C, parens 1 and parens 2. The Court of Appeals have had the opportunity to review this matter, including the extensive Dahlberg hearing that was conducted in this court. It took a number of days, if I'm not mistaken, 5. It was a long time, I know that. And based upon all of that and considering the court rule, I'm granting the defendant's motion in this case. However, if it is discovered during trial and that 2.118C 1 or 2 comes in, circumstances can certainly change. We'll just have to take it as we go along. But frankly speaking, again, I'm granting the motion, and the court will always keep in mind 2.118C because of the fact that, I just had a 3-week jury trial not too long ago, and there was a request to reform the pleadings to conform to the evidence presented, and the court will take it as it comes. So I'm granting the motion.
Thank you, Your Honor. Your Honor, the next motion is a motion in limine to keep the jury from hearing that plaintiff's expert, Dr. Leigh, has been sued and or settled a claim involving a bile duct injury occurring during a laparoscopic gallbladder removal surgery. Dr. Leigh, plaintiff's only expert, has testified that he has had 2 instances where he has had bile duct injuries occurring in a laparoscopic cholecystectomy, the same surgery that he criticizes Dr. Wells for in this case. And Dr. Leigh acknowledged that in neither of those cases did he do what he claims Dr. Leigh should have done here. In other words, convert to an open. So we want to bring into evidence the fact that Dr. Leigh had these complications because they support our theory that it's a recognized complication, and because it goes to credibility of Dr. Leigh. He says the standard of care is one thing, but on at least 2 other occasions, he has done something else. And I don't see plaintiff's response as contesting our right to raise the fact that Dr. Leigh has had these instances occur in the operating room. They haven't contested that. What they are saying is, if Mr. Martin brings up the fact that Dr. Leigh has had these surgical complications, they should be allowed to bring up the fact that Dr. Leigh was sued over that and that he agreed to a settlement of $1 million. And it's our position that the law is clear, that the fact that an expert witness has been sued is not relevant. It's not relevant, and it is much more prejudicial than probative. First of all, let's talk about relevance. Under MRE 401, relevant evidence is evidence that tends to make a fact an issue more likely than it would be without the evidence. There's nothing about the fact that one patient of Dr. Leigh's who had a complication decided to sue, and that Dr. Leigh, after fighting the case for quite a period of time, decided to settle, that has any bearing at all on whether or not Dr. Wells acted appropriately when he operated on the plaintiff in this case. So it's not relevant. And the case law establishes that. The primary Michigan case on that is Wishmeyer versus Chance, a Michigan Supreme Court case from 1995. And in that case, there was a neurosurgical procedure at issue. And the defense attorney cross-examined the...
That was back surgery, correct?
That was a back surgery, that's correct. The surgery at issue was a PLIF. And the plaintiff's expert had had some complications arising out of PLIFs that he had performed. And the Supreme Court said it was entirely proper for the defense attorney to cross-examine the plaintiff's expert regarding those surgical results. The Supreme Court also said that it was improper for the defense attorney to ask the plaintiff's experts about prior lawsuits. So that was error. In that case, they said it was harmless error, but it was error nonetheless. And there are 2 other cases that we cited that stand for the same proposition, the Bertini case and the Heschelman case. Both of those cases say it's error to bring up the fact that a medical witness has been sued in an unrelated case. And that's the situation we have here. There's not one case that plaintiff has cited that stands for the proposition that it is appropriate to bring up the fact that Dr. Leigh or any expert witness has been sued. Your Honor, what plaintiff wants to do is bring up the fact that Dr. Leigh has been sued, that he has settled the case, and presumably that he has settled the case for $1 million. That is more prejudicial than probative and should not come in under MRE 403, because it might suggest to the jury that, hey, because Dr. Leigh settled the case, that means that Dr. Wells did something wrong. Because Dr. Leigh paid $1 million, that means Dr. Wells should pay $1 million. Your Honor, if there had been another party in this case, it was a multi-defendant case, and one of the parties decided to settle, the jury would not be entitled to know that. So why, in a totally unrelated case, should the jury be entitled to know that Dr. Leigh made a decision to settle this case? At the Daubert hearing, it was established, well, let me back up a little bit. In his discovery deposition, Dr. Leigh acknowledged that he had this complication where a bile duct was clipped, but he said he took responsibility. And by that he meant that he eventually settled the case. At the Daubert hearing, it was brought out that he denied liability initially. He gave 2 or 3 depositions in the case, and ultimately, many months after the litigation started, he decided to settle the case. He settled it for $1 million, which was his policy limits. There are many reasons that people decide to settle cases that have nothing to do with the medicine involved. Cases are settled because attorneys and parties take into consideration, how does the plaintiff come across? How does the defendant come across? What are the damage claims? What is the amount of insurance? What is the jury pool like? All of those things that have nothing to do with what actually took place in the operating room. And this is especially true with respect to the amount of the settlement. The fact of the settlement is irrelevant, but the amount of the settlement in this case is more prejudicial than probative. If Dr. Leigh had had $200,000 in limits or $500,000 in limits, maybe the settlement would have been substantially less. And the fact that he paid policy limits also brings up the specter of insurance. So he's kind of put his credibility at issue when he says, I took responsibility. Well, what do you mean? I settled the case, but did any money come out of your own pocket? No, it was all insurance money. So this is a side issue. And plaintiff vociferously objected at the Daubert hearing when I went into what actually happened during the litigation. Many settlement documents contain a term that the settlement is not to be construed as an admission of wrongdoing. I wouldn't be surprised if language like that is in Dr. Leigh's settlement agreement. I don't know that because I don't have that. But that's the reality of the situation. If we go down that rabbit hole, we're going to be litigating what happened in Dr. Leigh's case and determine, did he really take responsibility? And what were the circumstances under which he finally settled the case? I don't think it's relevant. I don't think we should go down that rabbit hole. But I do think, as Witchmeyer says, what happened in the operating room with Dr. Leigh is relevant. What happened in the courtroom is not. And for those reasons, Your Honor, I would ask that the court enter an order prohibiting plaintiff from introducing any evidence that Dr. Leigh was sued or what he did with the case. Or if any questions, I'd be happy to address them.
I don't at this time. Mr. Walsh, your response, sir.
Yes, Judge. Ultimately, in medical malpractice cases, the credibility of expert witness is always paramount to the actions. And the fact that the defense wants to go into essentially these prior malpractice claims and limit the scope of the questioning really seems like that would improperly suggest to the jury that he was never sued. If they can talk about these complications and similar issues and other surgeries, seems like it would be an impermissible inference to suggest that he was not responsible for those the medical malpractice that he had committed. So we don't think that there should be cross-examination of Dr. Leigh regarding any prior surgeries unless plaintiff first opens the door by introducing evidence of the past medical malpractice settlements. So we think that case law looks at whether or not the evidence of prior lawsuits is admissible under very specific circumstances and for very specific reasons, and some of those reasons that it could be relevant include whether or not the witness's credibility and competency in doing the same procedure. And we think that it would be certainly unduly prejudicial for the defense to point out and suggest he's done the same things, but at the same time not to explain and discuss with the jury that he accepted responsibility for his actions of medical malpractice. And therefore, it would certainly be unduly prejudicial and unfair for the jury to not really be apprised of the full circumstances. It's ultimately relevant for several purposes. The fact that physicians must take purposeful conduct to avoid such injuries, and that when these injuries occur, it's common for physicians to settle them. So for those reasons, we believe this motion should be denied because essentially the defendants want to have their cake and eat it too.
Mr. Walsh, were you able to find any cases published or unpublished to indicate that settlements were allowed in a matter such as this?
Your Honor, I did not find any cases involving settlements, but I guess I would point out that in the Witchmeyer case that the defense kind of suggested to you, the fact there was a significant distinguishment in that case, and the expert witness testified that, let's see here. He was asked, have you ever been a defendant in a malpractice suit, doctor? His answer was no. You haven't? No. So in that case, he had no knowledge or recollection or evidence of that. And we think that's certainly distinguishable from the facts in this case. So, but to answer your question, I did not find, it's an unusual circumstance, Your Honor, and I don't know of any case law that's directly on point.
I'd have to agree. I've looked and high and low, and I couldn't find anything. Mr. Martin, any final rebuttal argument?
Yes, just briefly, to pick up where counsel left off on the Wishmeyer case. It goes on immediately after the portion that counsel just quoted, where they asked him that he had ever been sued, and he said no. He was then confronted with a complaint. The Superior Court of the State of California for the County of San Diego in the case of Christine Durango versus Donald Ignelz. Do you recall that? And he said, I don't really remember. But what did the Michigan Supreme Court say about that? In the very next paragraph, the Michigan Supreme Court says, the mere fact that an expert may have been named in an unrelated medical malpractice is not probative of his truthfulness under MRE 608 or relevant to his competency or knowledge. Thus, we find that it was improper for defendant to inquire into this medical malpractice against Dr. Ignelz. So this is a situation where potentially it was relevant to impeachment because he denied being sued, and then he was confronted with a complaint. And the court said, you can't do it. It's improper. It's not relevant. It's not relevant on truthfulness, and it's not relevant on competency or knowledge. That's the state of the law. That's the Michigan Supreme Court directing courts on how to handle this. And there has not been a single case where an expert has been allowed to testify about unrelated medical malpractice cases. So for those reasons, we've asked the court grant the motion.
Thank you. The court did read the case. Matter of fact, as of right in front of it, Wishmeyer versus Schanz, SCHANZ. That's cited 449 Mich 469. It is a 1995 case. Court also had the opportunity, amongst other cases to read, but the one court looked at as well as Heshelman, Heshelman versus Lombardi, Michigan Court of Appeals case 183 Mich. Ave. 72. It's a 1990 case. I believe that was before the Honorable Linda Heath Scott. I remember in Saginaw. And I remember her as a judge as well when I practiced down in that neck of the woods. Regardless, in this particular matter, citing the case in Wishmeyer, when the court had done their analysis relative to this, and again, this case was not relative to, well, was there a settlement amount? What was the settlement? Nothing like that. It was the questioning of the prior procedures done by this particular expert. And the court stated, we believe that this cross-examination was proper because during direct examination, Dr. Ignelzi testified that he had performed hundreds of back surgeries, including PLIFs, in order to establish his competency. And it goes on, gaps or weaknesses in the witness's expertise are a fit subject for cross-examination and go to the weight of his testimony, not his admissibility. And then the court kind of balanced that with the case cited by the plaintiff, Heshelman versus Lombardi, and that went much further. I mean, there was implications of MRE 608 in there, etc. In this case, we do have an acknowledgement by Dr. Leigh that indeed he was subject to this matter, a similar matter, and that he was indeed sued, and indeed there was some sort of settlement. There is no question after reviewing the case law in this case that the information sought by the defense relative to the past procedure is fair game because it goes to competency in order to establish his competency. And there's no question based upon what I read in the case law. Now, relative to, well, let's take it a step further. And well, yes, not only was I sued, but I settled them, or the matter was settled. Now, there, again, and I couldn't find any case law that says you could admit that. But when it comes to the settlement portion of it, and both parties cite MRE 403, then I'll back up first. The information is relevant under 401. It's not under MRE 403. Unfair prejudice. I don't find any unfair prejudice in it because the Supreme Court says it's fair game. However, when it comes to anything relative to being sued or a settlement, I didn't find any case law relative to that, number one. And number two, if that information were provided to members of the jury, in essence, one, potentially we're trying a trial within a trial, number one. Number two, the facts and circumstances may be completely different. Every surgery, every procedure is different. And to say that, well, yeah, I was sued and we settled under MRE 403 creates the danger of unfair prejudice. And that unfair prejudice is substantial, I should say the admissibility is substantially outweighed by the danger of unfair prejudice to the jury because, well, wait a second, it happened to this doctor who was an expert, he was sued and they settled. How much did they settle for? That's going down a rabbit hole that frankly is error as far as the court's concerned. I'm granting the defendant's motion in this case in entirety.
Thank you, Your Honor.
Let's finalize this with the use of deposition testimony. That's your client, right?
Finalize it with the use of.
Yeah, there's a motion relative to the use of deposition.
I'm sorry.
Judge, I understand your ruling, but may I just point out that evidence does not present a danger of unfair prejudice unless it threatens the fundamental goals of, Rule 401 and 403, and that's accuracy and fairness. I don't think the amount of the settlement is, certainly relevant, but I think the fact that he settled the case, it should be something that they hear about. I mean, ultimately, there is a case, the Parashini case, 238 Michigan Appeals 626, where the court held that the questions only pertaining to whether or not he was a defendant in other malpractice cases was not admissible because it didn't ask anything about specific alleged misdiagnoses. So they made a distinction between whether or not the underlying action was similar to the action at hand. So for those reasons, we believe that this is not, unduly prejudicial to the defense, because it really ultimately goes to the goals of, MRE 401 and 403, and that is, accuracy and fairness. So I just wanted to point that out for the record.
Objections noted for the record. Let's begin with, or let's finalize this with the final motion. Go ahead. Mr.
Yes, Your Honor. The third motion is our motion in limine to prohibit plaintiff from using the video deposition of Dr. Wells. The video deposition of Dr. Wells was about an hour and a half long. And under MRE 403, the court can exclude evidence, even if it's relevant, because of the needless, if there's a risk of needless presentation of cumulative evidence. And that's the basis that we're asking the court to prohibit them from using the video deposition. Dr. Wells is going to be here at trial. He's going to testify. He's either going to testify because plaintiff decides to call Dr. Wells in their case in chief. If they don't do that, I'm going to call him. So he's going to be here in person to testify. So what I don't think the court should allow is for them to play the hour and a half video deposition of Dr. Wells. And then I make a decision, okay, they've just presented the testimony of Dr. Wells. I put him on the stand in plaintiff's case in chief. Or, they play the videotape deposition and I decide to defer Dr. Wells' questioning by me until my case. They're going to cross-examine him either way, here and in person. So it's the needless presentation of cumulative evidence, and therefore, it's an hour and a half long. Why should the jury hear it multiple times? If the court has any questions, I'd be happy to address them.
I don't at this time. Mr. Walsh, your response, sir?
Yes, Judge. Until the jury, ultimately, MCR 2.308A states that depositions or parts thereof shall be admissible at trial or on the hearing as otherwise provided in Michigan rules of evidence. Ultimately, Dr. Wells, there's no reason to find that it would be cumulative without having him testify or having any testimony by it. I think it's proper for us to be allowed to present his deposition through party opponent admissions in our case in chief. And then if the defense wants to call them in their case in chief, that's certainly within their rights and that's their prerogative. But there's nothing that precludes us from allowing us to play his video deposition under the court rules, and because it is a party opponent admission, certainly not hearsay. And if that's certainly not cumulative, because it's our case, it's our burden of proof, and we decide what evidence we want to put on. If they want to call Dr. Wells in their case in chief, they certainly may do that. But to suggest that we are precluded from presenting his video testimony in our case in chief is, certainly not supported by the law. So for those reasons, we'd ask court to deny this motion.
Mr. Martin, rebuttal argument?
Yeah, just briefly, Your Honor. Under the hearsay exceptions, they do talk about, depositions not being excluded under the hearsay rule if the declarant is unavailable. Here, the declarant is going to be available, present and in person.
Well, interplay of MRE 403 as well as MCR 2.307. And certainly the deposition is fair game for presentation. And initially when the court was thinking about this, well, wait a second, the doctor is going to be here to testify. And under MRE 403, although relevant, and clearly it is relevant, and frankly, it's a party admission, the issue of undue delay, waste of time, or needless presentation of cumulative evidence is the issue presented by the defense in this case. However, the plaintiff has the burden of moving forward. And could it be cumulative? Maybe, I don't know. It's an hour and a half. But I still think it's fair game. Motion is denied relative to the use of deposition testimony. Present an order to that effect.
I will, Your Honor. Thank you. Can I just ask that the court, if they plan to do that, that they let me know, because there, I think, are perhaps going to be questions that pertain to some of the theories that now are not allowed. So there are going to be some potentially relevancy objections.
And I'm assuming potential redaction of some portions of the video.
Exactly.
Mr. Walsh?
Yes, Judge, I don't see that there's any need or reason to do that at this juncture. I don't know what parts, if, any will be played, so I just think that's a little premature at this point.
Your Honor, all I'm asking for is maybe a deadline for them to, if they're going to use it, to let me know so that I can go through it and indicate which portions of it I think are objectionable.
So presuming, and we're going to talk about the trial date here in a moment, but presuming the trial goes and on the scheduled date, how much time would you request? For a heads up, for a notice? Yeah.
2 days.
Oh, just 2 days?
Well, maybe I spoke too soon. If there's going to have to be argument over it, I should probably have 10 days notice so that we can, get something before the court to determine whether or not, or even 2 weeks.
How about that, Mr. Walsh?
That's, I would stand by my earlier comments.
Very well. Well, one thing I do prefer in any trial, I don't care if it's civil or criminal, is that we have all our ducks in a row before we call the jury, because I don't want to waste their time. And so I will require, despite the fact that the court ordered that the deposition testimony is fair game, that at least 14 days notice prior to trial must be provided to the defense that they will be using the deposition testimony. And frankly, I don't know what's in the deposition testimony, but there may be some information contained within that deposition testimony relative to the other theories that need to be excluded potentially. I don't know, but I will require 14 days notice relative to any issue of providing or displaying this information to the jury. That'll allow ample time for Mr. Martin to have at least some motion in limine before we go to the jury trial.
Thank you, Your Honor. I will include that in your.
It's just for purposes of fairness. I want to make sure we're all on the same page and that it's streamlined so that when we begin the trial, we can hit the ground running rather than having motions in limine while the jury's sitting in the jury. Any other issues at this time?
No, Your Honor.
Mr. Walsh, do you have anything else, sir?
No, but you mentioned trial date, so I there may be an issue regarding that. So
Yeah, I believe there is as well. And Ms. Hatch just stepped out. I'm not sure where she is. Will you be available for a phone call, Mr. Walsh, before the end of the day today?
yes, I should be, depending on I got several meetings this afternoon after 3 o'clock.
Okay. I was hoping for sometime this morning. Oh, we can do it via email as well. Thank you, Mr. James.
Your Honor,
Go ahead.
is this a result of the letter that I sent to the court about the 13th trial?
Well, let's ask Ms. Hatch.
What?
The trial date.
We need to adjourn.
We need to adjourn. Is it regarding the letter or is it we have another matter scheduled that day?
Oh,
Both.
Okay, because I think it's most likely I'm not going to have an actual conflict. So, but if there are other reasons, then I think it's better.
We have a criminal trial scheduled.
juvenile. Yeah, juvenile.
I have a juvenile trial the very same day. Walsh, you were going to say something. I interrupted.
I have a vacation that was planned the second week that was concerning to me. So if this was going to be adjourned, I think that would eliminate all my concerns and anguish that I've had to figure out how I'm going to satisfy my wife on this anniversary trip.
Happy wife, happy life.
That's right.
I get it.
You get some notice, right?
Absolutely. We are going to adjourn the trial date. Court finds good cause to do so. In part based upon the juvenile jury trial, which is scheduled and actually has precedence, as well as unavailability of plaintiff's counsel. And if I have to say happy wife, happy life again, I will. So we're going to get a new date right now.
I'm looking at March 5th.
How many days of trial are we talking about here?
I think we can get it in probably 4 days, possibly 3, but more
Mr.
likely
Walsh,
4.
how about you, sir?
I would think 4 is safe. I mean, yeah, I think maybe 4 or 5, depending on how things play out.
Your Honor, just yesterday, I scheduled a ski trip actually starting February 29th. Now, I don't know if it makes a difference or not. My wife is not going, but
Even Mr. Walsh smiled at that one.
Right.
How about April 2nd?
April 2,
My calendar appears to be free.
we have a moment.
April 2 is a good date for me.
I'll send them.
We have a trial date. We'll send a notice for April 2nd, 2024 at 9 a.m. All discovery cutoff, motion cutoff follows along as in the previous order. Discovery remains open up until 28 days from trial. Any motions or motions in limine need to be heard no later than 14 days from trial.
Thank you, Your Honor.
Thank you, Mr. Martin. Mr. Walsh, thank you, sir. I believe
Thank
that'll
you, Judge.
conclude. And you can tell your bride there will be no more angst or worry. You're going on your trip.
There we go.